1 CR 11553, State of Texas versus Leila McFarland. Now parties announced for the record for the state.
Jason Gearhead, Your Honor.
Defense.
Richard Garcia for the defense. Ready, Judge?
Are you Leila McFarland?
Yes, ma'am.
Showing you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that document with your attorney? Did you understand it?
I did, Your Honor.
Are you the same Leah Beth McFarland who was placed on deferred adjudication in 2021 CR 11553 for the—
Buckle up, guys. Today we're heading into a tense courtroom where Leila McFarland is facing the fallout from breaking her probation terms. Originally on deferred adjudication for assaulting a peace officer, she's now admitting she violated condition number 41. And the moment she pleads true, everything shifts. The stakes? Up to 20 years in prison. Let's see how the court responds to this sudden twist.
Offense of assault peace officer judge on February 23rd, 2022 for a period of 5 years. Is that you?
Yes, Your Honor.
All right, state.
Violated condition number 41 on or about the 18th day of July 2023 in Bear County, Texas. The defendant Leah Beth McFarland did not there failed to comply with the rules, regulations, or instructions of the Bear County Community Supervision and Corrections Department's duly diagnosed residential facility, and that the defendant was unsuccessfully discharged in violation of condition number 41.
How do you plead to that? True or not true?
True.
Did you understand by pleading true to violation of condition number 41, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, Your Honor.
Knowing that, do you—
After Leila confesses to the violation, the state offers a resolution, revoke her supervision and send her to prison for 2 years. But the judge isn't done yet. Before anything is finalized, probation is asked how she was doing otherwise. That's where things get murky. Her performance may not have been all bad, but what's coming next reveals why that wasn't enough to save her.
you still wish to plead true to violation of condition 41?
Yes, Your Honor.
Court will find violation of condition number 41 true. Is there a proposed resolution?
Yes, there is, Your Honor. And that is to adjudicate guilt or revoke the individual's community supervision, sentence her to 2 years of the Texas Department of Corrections.
All right, probation. How was she doing other than not completing this? All right. So is there a reason you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Leila tries to defend herself, explaining she complied with many conditions, paid fines, showed up for visits, but mental health and substance abuse programs weren't completed. She says she got them done while incarcerated previously. But then she blames panic attacks and communication issues for being discharged from the mental health facility. The tension in the room keeps rising.
All right. State your name for the record.
Leah McFarland.
All right. So what happened?
I got onto probation and I paid a fine. I did my proof of address. I showed up for visits, but what I didn't get done was the mental or the CTA. It's some kind of drug and alcohol maybe, and then there was a mental health exam, but I got those both in jail the last time I was incarcerated.
So why are you not following the rules with mental health?
Oh, I went to DDRF and I don't know, they said that I panicked a lot, and they said that I was talking when I shouldn't have, and I just got a bunch of write-ups that
All right.
I'm not.
Just one moment. Probation. Any objection to the court reviewing the documentation for probation?
No, Your Honor.
No, that you're making it seem like these were light infractions. These were not.
This is where the judge draws the line. Leila may downplay her misconduct, but the court isn't buying it. These weren't minor slip-ups. The judge calls out specific incidents, profane insults like effing B, that prove her behavior was far more serious. Defense simply asks the court to stick to the deal, but it's clear this judge isn't letting anything slide today.
Not light infractions on your part.
I'm sorry. I was trying,
No, I mean, when you call somebody an F and B, that's not a light infraction. All right. Anything, counsel? Any questions?
No, Your Honor, we're just asking that you follow the agreement with the state.
All right. The court,
The hammer drops. The court finds the violation of Condition 41 true and overrides the state's offer, sentencing Leela to 3 years in prison instead of 2. She's handed a trial court certification and warned that her appeal rights are limited. That's it. Deferred adjudication is over. Leela now has a felony conviction, and the consequences just became very, very real.
is going to find violation of condition number 41 true. Court is going to grant the motion. Court is going to sentence you to 3 years in the prison, give you credit for any time served. I'm going to show you what's entitled trial court certification. You can go around, Richard. I'm going to show you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
yes,
All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on deferred adjudication. Do you understand? You have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you're on deferred adjudication. Do you understand?
sort of. Can
All
you
right.
explain it more?
Sure.
Okay.
So you can file a notice of appeal or have your attorney file a notice of appeal. That notice of appeal is not for the fact that you are on deferred adjudication. Do you understand?
Yes,
But the notice of appeal can be based upon.
As Leela is led out, the judge delivers a sobering reminder. Mental illness doesn't excuse cruelty. That one-liner cuts deep, sending a message that accountability still matters, even with personal struggles. This case ends not with mercy, but with a reality check and a 3-year prison sentence that could have been avoided with just a bit more responsibility.
On the allegations that were in the motion. Do you understand? I'll let your attorney explain it
I'll
to you.
explain it to you.
All right. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yeah.
All right. Good luck to you.
thank you.
We can go off the record. You cannot use your mental illness to be mean to people. Do you understand?
Yes,
All right. Good luck. 23 CR 2912 State of Texas versus Christopher Trinidad. Can I have parties announced for the record for the state?
Travis Thanks to the state of Texas.
Defense.
Rafael Leal for Christopher Trinidad.
Are you Christopher Trinidad?
Yes, Your Honor.
Counsel, have you received all the discovery and did you review that with your attorney?
Yes,
I'm sorry, with your client?
yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Trinidad, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
And did you sign it?
Yes, Your Honor.
Showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Trinidad, I'm showing you what's entitled court admonishments and defendant's waivers and affidavit of admonitions. Did you review that?
Next up, a new case is called Christopher Trinidad, a security guard now facing aggravated assault with a deadly weapon. He confirms everything, the indictment, the charges, and the terms of his deferred adjudication. The court explains his staring down a second-degree felony with up to 20 years. Another defendant, another chance to dodge prison, but will he hold up?
With your attorney, did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with aggravated assault with a deadly weapon? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
All right, after reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, the situation with my client was that he was a security guard. Got home, there was an argument. It ended up in him being arrested. Through my investigator, there was we approached the complainant. The complainant, it's fine with not wanting to pursue anything further against my client. And in fact, she signed out of her own volition, her own accord, a affidavit of non-prosecution. However, given my client's situation, and he accepted the agreement that was presented to you, and he is willing to abide by those conditions, Judge. And I also have a motion in order for the investigator that helped me out in assessing the case.
All right, so Mr. Trinidad,
Yes, ma'am.
what is this that I'm reading the police report about your video recording? What was that about?
The video recording?
Yes, in the police report,
Christopher's attorney steps in to paint a clearer picture. It was a domestic situation, a heated argument at home. The alleged victim, his own family, no longer wants to pursue the case and signed a no prosecution statement. With no opposition, Christopher accepts the deferred adjudication deal. But there's one problem left. The police report hints at something bigger.
it says that you became enraged because one of the complainants told the other complainant to be careful because you're recording. They said that wasn't characteristic for you. So what is the recording about?
No, I'm just upset, Your Honor. I just,
Well, were you recording or not?
was I recording?
Yes, recording,
Oh, no, ma'am.
recording other individuals because that's what's in the police report.
No, ma'am. Sorry.
How do you know these people?
They're my family.
Ah, so we have another family situation. So where are you going to be living? By yourself at another location because you're not going to be allowed to have contact.
I have another location where I can look to. Yes, Your Honor.
All right. Do you have any prior mental health diagnosis?
No, ma'am.
Are you employed?
I was
Doing what?
security officer.
All right. Do you have any children?
Yes.
What are their ages?
My son is 13. My daughter's 22, but she lives with my previous wife.
And so where's the 13-year-old?
13 is at home
With, who's he with?
with my wife.
Okay. So you and your wife are still together?
Yes, ma'am.
And who is your wife? What's her name?
Maria Chavez.
Ah. So what's the name of the 13-year-old, the first name?
Felix.
State, you put in here no contact with Chavez. Who is Chavez?
Sorry.
My name is Happy. I upload courtroom video for education purpose. This video may contain copyrighted works not specifically authorized for use, but believed in good faith to be protected by the fair use doctrine under Section 107 of U.S. copyright law.
The judge confronts Christopher about strange behavior, allegedly recording family members and growing enraged. He denies it, but red flags rise. As more personal details come out, his job, his kids, his wife, it's clear this isn't just legal trouble, it's family drama on full display. The court imposes a strict no-contact order. One slip, and he's behind bars. Make sure to like this video, subscribe to the channel, and we'll see you in the next video.